The last topic in this chapter is about the legal, I'll call it the legal issues. And most of them have to do with Fourth Amendment. So when you are obtaining evidence and information from a crime scene, we have to be very careful about the Fourth Amendment rights, which is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure. So if we find that that gets violated, it means the evidence can't be used in a court of law. And that becomes, it becomes very important that when evidence is collected, it's done so in the proper manner so that it will be able to be used. The big idea, of course, is that for the most part, you're going to need a search warrant. You cannot take evidence from a suspect without a search warrant. To get a warrant, you have to have probable cause. And then that warrant will be specific as to exactly what can be searched and anything that can be taken. Those are all things, details that get included on a search warrant. There are, of course, warrantless searches. There are some cases, some instances, let me say, where a search warrant is not necessary for collection of evidence or for a search. And these are these four cases that you need to, four criteria that would be cases in which you could use a search without a warrant. The first one is the existence of emergency circumstances. Somebody's life is in danger. Like, okay, there's a kidnapping victim and we need to be able to search this because the kidnapped victim may be dying if we don't act on this right away. Someone might be killed. There is somebody with a, we think that there's a person with a gun in there and they have another person that they're going to kill. So that would be an emergency circumstance where you need to come in and search. Those are fairly rare. A similar one is about loss of evidence. Some kinds of evidence are time sensitive or can be destroyed pretty easily. So if there was a belief that the immediate loss or destruction of evidence was imminent, then they can step in. So this can be in certain cases with fire evidence, blood alcohol content evidence, toxicology is time sensitive, or if there is information to suggest that the suspect is in the process of destroying evidence. Additionally, if an arrest is being made, a lawful arrest is being made, during that search, during that arrest, you can do an immediate search of the person and the property within the immediate control of the person. So what we say is if that person is sitting in a car when they're being arrested, you can search the interior of the car. If they are out not in a car, you pretty much can only search that person themselves, what's in their pockets, in their shoes, but not things that are in the periphery. So it basically something under their immediate control. A search can be made by with consent as well. So that's the fourth one we tend to forget. So if you ask somebody and they give consent to a search, then it's a legal search without a search warrant. Another thing that comes into the legality, as we've sort of mentioned, is this chain of custody. So a chain of custody is basically a list of all the persons who came into possession of an object at what time, what date. So from the beginning of the crime scene, if a piece of evidence is secured, who had it at what time, and it needs to stay in possession of a particular person. So the investigator collects it, it retains in their custody, they turn it over to a lab, the lab technician signs it in, now it's in their custody. When they are finished analyzing it, it's delivered to wherever they store the evidence, and then it's turned over to somebody who's securing that, the lockup. And so continuity of possession is needed. If at any point you cannot prove who had it, and it could be had by a third person, a third party, then it could have been altered, it could have been played with. So that means that there has to be a documented chain of custody showing who had it when. And these things are going to be important when it's like, is it labeled properly? Is it sealed to ensure that only the logged personnel handle it? Is it, were the evidence forms properly completed and complete. That's going to be things that they would consider under a chain of custody. Here's an example of a sample up form that Louisiana State Police Lab uses, and you can kind of see the types of information. They need to know what is the crime, what is the case number, who's turning it in, who is the investigator, what are you turning in, and some description of it and what is to be done with it. A couple of key landmark cases we'll talk about in this chapter are Mincy versus Arizona and Michigan versus Tyler. Both of these have to do with those warrantless searches. So Mincy versus Arizona had to do with a homicide scene. And so that was the legality of a 4-day search. And they determined that the evidence was illegally seized because there was no warrant issued and there wasn't enough evidence to suggest it needed a warrantless search. So that one was a homicide. The other one was Michigan versus Tyler, was a fire scene. And they initially went in and collected evidence and searched it under the condition of the evidence could be destroyed if you didn't get it right away, which is true. So accelerants will evaporate. So they said that first search was legal. However, they came back 4, 7, and 24 days later and collected more evidence. And they said that that was not warrantless. The first search met the warrantless search conditions, but the day 4, day 7, day 24 did not. Those needed to have a search warrant, so all of the evidence was not accepted.